Let's start with Video 1, what evidence is and how the court accepts it. What is evidence? Evidence is anything presented in court to prove or disprove something. Testimony and exhibits are examples of evidence. Why are there rules for evidence? There are Colorado rules for evidence that tell you whether or not a court will let you use a certain piece or type of evidence. Depending on the rules, evidence will be either admissible, which means a court will allow you to present the evidence, or inadmissible, which means a court won't allow you to present it as evidence. In order for the court to accept evidence, the evidence must be relevant, meaning the evidence must be related to the issue the court is dealing with. Even if a piece of evidence is relevant, a court may still decide that it is inadmissible for other reasons, such as unfair prejudice, wasting time, or misleading the jury. Example: relevant. Evidence that the defendant has an insurance policy on his wife before her death is relevant in that while it provides a motive as to whether or not he is guilty of murder, it does not prove he is guilty. Not relevant. In a burglary case, evidence that the accused burglar committed another unrelated crime in the past is likely irrelevant. The evidence must be authenticated. This means you must show the court that the evidence is what you say it is and that it is real and not forged. The evidence must be admissible. The opposing side may object to certain evidence that they do not want the court to see or hear. If they object, you will have to tell the court why you think the evidence should be admissible. If evidence is admissible, it means the court will consider the evidence when making a decision about your case. Example: if you try to present evidence of child abuse that you believe is relevant, authenticated, and admissible, and the other party objects, you must tell the court why the evidence should be admissible. The judge will rule on an objection by either sustaining or overruling the objection. When an objection is sustained, this means that the judge agrees with the lawyer's objection. When it is overruled, this means the judge doesn't agree with the lawyer's objection and you may present the evidence. If the opposing side objects, you will tell the court why you believe your evidence is admissible. What is hearsay? Hearsay is anything someone said, wrote, or gestured, like a head nod, outside of court, that you are trying to present in court, to prove the truth of what you are trying to tell the court what happened. Example: if the defendant is on trial for the murder of his wife, and a friend of the wife is brought in by the prosecutor to testify in court that the wife told her, "I'm terrified of my husband because he threatened to kill me," this is hearsay. Hearsay is the most often used objection. Why is there a rule that doesn't allow hearsay? The rule exists because each party in a case is supposed to have the right to cross-examine, which means asking the witness questions about what the witness testified to. For example, if a witness states that he saw the accused burglar walk away from the bank with a stash of money, the accused burglar has the right to ask the witness questions about what he saw, such as, did the witness have his glasses on, and how far away from the bank was the witness? This rule on hearsay often comes up when dealing with things children have said, because courts usually don't allow children to testify in domestic relations or family cases. Just because something is hearsay doesn't mean it's automatically inadmissible. It can still be admissible. Let's review a few examples. Statements made by the opposing party may be admissible. For example, the defendant driver at the scene of the car accident said, "I'm sorry, it was my fault. I wasn't paying attention to the road." This statement is later offered by the plaintiff as evidence. Excited utterances or statements made in the heat of the moment may be admissible. For example, if a child was just abused and ran into the room crying and telling another person about the abuse. A present sense impression or a statement said that describes something. The person said the statement during or right after she saw it. For example, a witness testified that the victim looked right and yelled, "The car is spinning out of control towards me," right before being hit by the car. A statement made for medical diagnosis and treatment may be admissible. For example, a doctor testifies in court that while she was at the scene of a bus accident, a bus passenger told her, "I've got a bump on my head and I have a bad headache." Statements made by children in the case of sexual or physical abuse. There are several Colorado laws that allow children's statements regarding sexual or physical abuse to be admissible. Click on the links below to go to Video 2, Evidence in Family Law or Domestic Relation Cases, and Video 3, Other Types of Evidence. Also, click on the survey link below to provide feedback so we can improve on these videos. Thanks.